Hello. Thanks for listening to the Go Beyond Disruption podcast, where we share insights from inside the accounting and finance profession that help you stay ahead of the curve, whatever sector you work in. I'm Steven Menges, and this week I'm coming to you from CPA.com in Northern California, USA. This week's episode is called Modernizing Your Practice 2, Numbers, EPL, and Matters for Consideration. And it includes experts on topics that are very relevant to many firms today. Experts that provide some clarity around complex liability, legal, compliance, and risk management topics facing firms and other organizations in 2020 and beyond. First up, you'll hear from Rebecca Toffolon, JD, the Assistant Vice President, Accountants Professional Liability Claims at CNA. And she's going to be talking about the real cost of liability risk. After my chat with Rebecca, segment 2 features Laura Lapidus, an employment attorney and management liability and EPL risk control director at CNA. Timothy Domanick, a principal at Jackson Lewis PC, which is one of the country's preeminent workplace law firms, and me, your Modernizing Your Practice lead, Steven Menges, as we all discuss a topic that is especially important to growing firms, employment practices liability risk, or EPL risk. In segment 3, CPA.com's Matt Towers digs into matters for consideration and how to build a quality and risk wellness plan with his guests, Richard Hill, a peer reviewer for over 25 years and the managing partner at Mitchell, Emmert & Hill PC in Knoxville, Tennessee, Kristy Illuzzi, Senior Technical Manager and Staff Liaison to the AICPA's Technical Issues Committee, and Mike Glynn, Senior Manager with the Audit and Attest Standards team at the AICPA. Let's get into segment 1 now. With me today is Rebecca Toffolon, JD, from the Accountants Professional Liability Claims Department at CNA. If you're not yet familiar with them, CNA is the underwriter for the liability insurance that many CPA firms rely on to better manage their risks and grow profitability. CNA's extensive experience and history in handling accountants' malpractice matters provides a roadmap of CPA firm liability risk areas on which to focus. And CNA's claim professionals bring unique perspective and expertise in liability risk. Welcome to the podcast, Rebecca.
Thank you, Steve. I'm happy to be here.
Rebecca, tell us a little bit about CNA and what the company does for CPA firms.
CNA is the market leader in providing accountants professional liability insurance. We insure firms of all sizes and assist them with resolving claims and mitigating potential claims. We also have an active risk control team that helps firms improve the risk management through a number of different educational forums, as well as a hotline that insureds can call with any questions that they have.
So how long have you been there, and what is your role there?
I've been at CNA for 13 years. I've had various capacities handling professional liability claims during that time. My current role, I am the Assistant Vice President overseeing the Accountants Malpractice Claim Team, which consists of 14 claim professionals who are dedicated solely to handling accountants' professional liability matters.
Okay. So you're a lawyer and have a master's in negotiation and conflict resolution. So your understanding of liability claims spans all the different ways that claims against CPA firms are ultimately resolved, correct?
That is correct. When I started handling professional liability claims at CNA, it became apparent to me that most matters were resolved through mediation and negotiation instead of through trial. The claims that did resolve through alternative dispute resolution, or ADR, usually resolved earlier and with better results. I wanted to learn more and hone my skill set towards ADR to better serve our insureds, so I went back to school at night and I got a master's degree in negotiation and conflict resolution to round out my legal experience.
Wow, that's great. So what size of firms are you seeing reporting claims?
I guess I should first clarify what we consider an actual claim. We define a claim as a demand for money or services. And while I think everyone anticipates claims against large firms, the bulk of actual claims that we see that were reported to us in 2018 were from mid-size and small firms. 1/3 of all the actual claims were actually from firms with 3 or less practitioners.
Those are interesting numbers, especially, how many claims or what percentage of claims are coming against smaller firms. What other types of matters does your team assist with?
I think one thing that tends to surprise CPAs, especially at smaller firms, is that the bulk of what is reported to CNA on a yearly basis, at least in recent years, is not actual claims, but potential claims and subpoena assistance matters. Only about 20% of what was reported to us in 2018 were actual claims at the time the matter was reported.
Okay, so I'm guessing it's very helpful for the firm, for a firm to let their insurance company know about a potential claim so as to get ahead of it then.
Definitely. The benefit to reporting a potential claim is that we may be able to prevent the claim or mitigate any damages. Similarly, if a CPA is served with a subpoena for records or testimony, we can provide an attorney to help them respond to make sure that they don't turn over any documents that they shouldn't or say anything that may cause a claim to be made against them in the future.
So just responding to and dealing with claims has to be a resource burden on the firm. So what is the average length of time from a claim filing until it's finally resolved?
The average in 2018 was 14 months to completely resolve and close out a claim. It definitely can be a burden on a firm. You're right, both from a time and resource perspective, as well as from a psychological perspective. It can mentally be draining and stressful, worrying about the outcome, and even to potentially be deposed or go to trial.
Wow, 14 months is the average? Wow, I think that statistic deserves attention and a name. So I'm going to call it the pain period because of all the pain and work disruption at the firm that is dealing with the claim. I'm going to give it that name. I like that, the pain period. So if the overall average is 14 months, what do the numbers say about audit claims in particular?
Audit claims can definitely have a significantly longer pain period. They usually involve extensive discovery and complex, sometimes multi-party litigation. So it can be several years before an audit claim will resolve. Okay.
Wait, so you're saying they can be multiple years long?
I am.
Wow. Clearly then firms need to focus on minimizing liability risk for audit engagements. And that includes using best practices for engagement letters. And it means really understanding privity in third-party audit claims. Other interviews in this Modernizing Your Practice podcast series do cover those two topics. So I encourage folks to check them out at cpa.com/MYP to check out those other podcasts in this series on those two topics.
Those interviews with Stan Sterna and Sarah Ferentz were excellent. I definitely would recommend them.
What do the payouts look like for the different types of liability claims?
That's a good question. It's hard to provide a general guideline for what payouts look like, as they tend to be very fact-specific. Claims from large insureds also tend to skew numbers up drastically. So to give you an idea of average payouts, we looked at small to mid-sized claims at CNA that closed from 2007 to 2016. And based on that, the average payouts for a tax claim were $29,000. For a consulting professional liability claim was $60,000, and for an audit professional liability claim was $138,000. $
138,000 average to resolve audit claims. Wow. So audit claims are both the largest and have the longest pain period then.
That's right.
Okay. So we mentioned the importance of engagement letters to reduce liability risk earlier. So I'm curious, is there any link between not having an engagement letter and liability claims?
Well, only 69% of actual claims reported to CNA in 2018 had an engagement letter. A strong engagement letter can probably help avoid a number of claims, especially ones where there just isn't clarity as to the CPA's roles and responsibilities. And then taking it one step further, if a claim does come, it helps with the defense in explaining the scope of the engagement and potentially in limiting damages. So on the flip of that, not having an engagement letter can definitely hurt the defense in the scenarios specifically where there is a dispute as to whether it was the CPA's responsibility to do something. Those scenarios then turn into a sort of he said, she said scenario that can be difficult to defend.
Wow. So if 31% had no engagement letter, then I'll again recommend folks listen to our podcast on engagement letter best practices. Okay. So to finish things off for today, can you share about the why and the who in the claims data for the big money claims that can help firms assess potential risk?
I can give some leading indicators of severity from a review of closed CNA claims in 2017, where we made an indemnity payment of $1 million or more. This data set covers claims from 2008 to 2014. Speaking of that pain period for audit, specifically, what we found most often in these $1 million plus payouts, the fact pattern involved a failure to detect a large embezzlement or a fraud. Another scenario that was common was an audit of a failed or distressed company. And I should mention the 2008 to 2014 time period, that was also included some claims, a good number of claims after the financial crisis. So that audit of failed distressed company was probably pretty relevant in that time frame due to that as well. And the third scenario was a lack of independence, either in fact or just in appearance.
Very interesting. Seeing that lack of independence makes the list. What about the other firm practice areas?
Sure. For non-audit engagements, some of the recurring red flags that we saw were the client was a wealthy client or a celebrity. We also saw engagement creep and over-reliance on the CPA firm. Often those three would go together. And then the fourth pattern we saw was investment advice was given. Generally speaking, the themes that we see that span across all types of claims is really the size and the severity of the underlying loss, regardless of liability. And if you have a $100 million damage model, even with a 1%, 2% liability, that would still be a pretty large loss. We also saw underlying matters involving fraud or embezzlement, regardless of the type of engagement. Very typically, any sort of a fraudulent scheme, anyone that was involved, any professional involved gets pointed to that they should have seen it, regardless of really what their role and responsibility was. Another overarching indicator we saw was the client was a financial institution. Again, some of this probably because of the time frame of the claims we're looking, failed banks was a big result coming out of that financial crisis. So that particular financial institution being a client may have a little bit of timing from the claims we were looking at. And the last one that we saw, regardless of the type of engagement, when the CPA firm was alleged to be involved in improper activity. That's was a pretty big red flag and severity driver.
Wow. Okay. So that last one was that the CPA firm was alleged to be involved in improper activity. That's interesting. It's also fascinating that wealthy clients and celebrities being risky as clients makes sense. And again, we see engagement scope creep as an issue for firms to address, including being careful to not be seen as providing investment advice in other engagements. Okay, so Rebecca, any final thoughts for firms before we wrap up this podcast?
I have a couple, Steve. First, I'd urge firms to take note if any of their engagements have any of the potential severity indicators we talked about. If so, I would encourage them to review their processes and procedures around that engagement, as well as you mentioned, to ensure they have a strong engagement letter for that client. My second thought would be to encourage firms to account for and have a plan in place for dealing with a claim, as it's likely one is going to be made at some point, and the better educated and prepared a firm is, the easier the claims process will be for them.
Thanks, Steve. Hi, this is Kyle from the London office of AICPA and CIMA, and I help make this podcast, obviously, which means I have the power at my fingertips to interrupt Steven, but not for too long. I'm doing so because I wanted to play this. It's the sound of people getting together. Remember that? Well, it reminded me about the AICPA's annual Engage event. And that's an event which we always get excited about because our podcast launched at Engage 2018, almost exactly 2 years ago this month, this June. Sure, we get excited about it, but we're not the only ones. So I have this question for you. Do you know about Engage 2020? It's our annual premier event for accounting and finance professionals, and this year it's online. And you'll hear from dynamic speakers about timely topics, including COVID-19 guidance. So join us July 20th to the 24th, and if you register before the end of this month, June 30th, 2020, you'll save $150 at checkout, and you'll see that offer in US dollars wherever in the world you register from. To do that, just go to AICPAengage.com. We'll also put a link in the podcast notes to this episode. Right, interruption over. I'll let Steve get on with the rest of the episode as he continues his focus on how to modernize a CPA practice with Laura Lapidus and Tim Domanick, and they'll explore how to manage employment practices, liability and risk, how to help a firm grow in a way that's fast and furious and safe. Back to Steve.
With me today is Laura Lapidus, an employment attorney and the Management Liability Risk Control Director at CNA Insurance, and Timothy Domanick, Principal at Jackson Lewis PC, which is one of the country's preeminent workplace law firms. Laura and Tim, before we get into employment practices liability risk, tell us a little bit about your background and experience working with employment law and risk.
Thanks, Steve. I'm an employment attorney. I've worked in an employment litigation firm. I've actually been in-house counsel both on the government side and also for a private company, a restaurant company. After that, I went into the insurance business, and I spent about 10 years handling employment practices, liability claims, and other types of management liability claims for various carriers. And I've been in this position at CNA for about 10 years now, where my responsibility is really to assist our policyholders in managing employment risk.
Actually, Laura, tell us a little bit more about your company.
CNA provides insurance, all types of insurance. I focus on management liability, in particular employment practices liability insurance. And we provide that to all types of industries, particularly to accountants. We have a special program for our accountants with the AICPA.
Okay, great. Thanks for that. So how about you, Tim? Tell us a little bit about yourself.
I've spent my entire professional career working in labor and employment law firms. Initially, straight out of law school, I worked at a firm where I did both sides of the coin. I did plaintiff's work and defense work. So, representing employees that had problems against their employers, and then, of course, representing employers when they had issues that they needed to be addressed. At this point now, I'm a principal at one of the nation's largest labor and employment law firms. All we do is management side of labor and employment law. So we help employers of all sizes, from the small mom and pop shops to the Fortune 100 companies, to address any of their employment needs, whether it be standard advice and counsel work, God forbid if you get there, straight through to litigation.
Laura, tell us a little bit about EPL, employment practices liability, and EPL risks in general today, kind of across all companies.
Well, employment practices liability insurance is a type of insurance that provides coverage not only for your damages, which would include settlements, or damages through a lawsuit or otherwise, but it also covers your defense costs for covered claims. And typically, it relates to employment-related claims such as wrongful termination, discrimination, harassment in the workplace, and of course, retaliation is covered as well under most of these policies. As far as the type of risks that we're seeing today, there's so much. The laws are changing so rapidly, but some of the top risks that we see, obviously sexual harassment has really been in the forefront over the past few years in light of the Me Too movement. So there's been a real spotlight on that. We're also seeing issues relating to pay equity. So there have been a lot of complaints about equal pay. Disability accommodation and discrimination and leave laws also there's a lot of issues that employers have to deal with relating to those topics. And those are the areas that a lot of employers get tripped up in because the laws are so complex. And then you've seen issues lately in the past year or two with marijuana in the workplace as it's been legalized and decriminalized in various states. However, it's still illegal under federal law. And then last but certainly not least is retaliation. And it's relatively easier to prove a retaliation claim, and I'll let Tim take it from there. But we see a lot of issues with respect to retaliation under various employment laws.
Yeah, and just to bridge off of what Laura said, I mean, a lot of the claims that I wind up dealing with and the firm in general winds up dealing with often is retaliation claims. When you have these types of employment-based situations where you have a problem with an employee or there's an issue that gets brought up, a lot of times an employer will handle the situation okay, not great, but okay. And then it also can lead to a potential retaliation risk. As Laura says, it's its own standalone claim, which can be very, very easy to prove at times, or at least easy enough to get to a jury. It's causation, it's story, it's cause and effect. Somebody did something to me, so as a result, the employer reacted poorly and retaliated against me as a result.
That's interesting, and I had heard that before. I've studied EPL a little bit, and it's something I've been interested in because it really is a factor for every company. Employment practices liability and kind of the things you guys talked about. Discrimination in the workplace, sexual harassment. But that's one thing I did constantly hear was that retaliation is pretty much always on the leaderboard, so to speak. And that's not a good leaderboard. That's a bad leaderboard. But that retaliation is always up there, as something that, unfortunately there are a lot of claims in that area. And it's interesting for you to say that it's actually fairly easy to prove retaliation as opposed to maybe some of the other areas.
Oh, yeah. As far as how often that they get filed, even in 2019, the EEOC, released their statistics for the year end of 2019. And in more than half of the cases that are filed, there's a retaliation component. And, look, when I say that they're easier to prove, they're easier to prove than a standard discrimination case because, what could be considered discrimination or what could be considered harassment sometimes is, within the eye of the beholder a little bit. But for retaliation, the name of the game, if you're a plaintiff's attorney, is just get it past a judge to the point where you're going to get a jury trial. And then maybe you can convince 8 or 6 people that are sitting in a box that, hey, if you went to your employer and you had a problem and they did to you what they did to me, how would you feel? And it's an emotional component.
That is interesting if you kind of think about that, taking it forward to, getting it in front of a jury. Because I think most people have probably experienced or know someone that's experienced an issue at work where they kind of reported something and didn't necessarily get what they felt was an appropriate response from management. I also thought it was interesting earlier, Laura, when you mentioned that leave, that basically, with the changes in leave policies that companies have, that you're seeing EPL activity around leave. Is that are you talking about like family leave, or what type of leave are you talking about?
Usually, family medical leave, and there are some state statutes as well, now that those are being enacted. So, they tend to be complicated issues, especially, for smaller firms that may not have the expertise on the human resources side to deal with some of the issues that are presented in that context. Obviously, for family medical leave under the federal law, you're talking about, larger employers. But, new leave laws being passed, it's something that employers need to keep an eye on.
No, and that makes sense, and I think it's one of those things where if a firm is smaller, they've never really had anyone attempt to use these leave policies. Some of these policies are newer, and in some cases, a smaller firm, even if if their state had a family leave policy, their firm may be small enough that no one ever tried to use it before. So it's kind of a new thing for them. So I can definitely see that. So now thinking about CPA firms, what are some unique factors around EPL that are impacting CPA firms?
Well, I think when you look at CPA firms, some of the issues that come up are that there are high wage earners involved. So if you have a high wage earner, that's going to impact your damage calculation and the potential for damages. The other thing we see with respect to CPA firms, and to some extent other firms like law firms, or are in the harassment arena, if someone's being harassed by a rainmaker, if you have any type of issue, whether it's harassment or otherwise, where the person who is the alleged bad actor is a rainmaker, it's difficult for a firm to deal with it because that's the person bringing in their money. Unfortunately, a lot of times firms may be more lenient because the rainmaker is responsible for drumming up business, and there would be a loss of business if they disciplined or terminated that rainmaker. But if they don't, then they have employment risks to worry about. So, we see that come up. I mentioned the pay equity issues. And one of the things that we see in claims, which is understandable, is that when you have a claim, whether there's a performance issue involved or some type of employment dispute, as you can imagine, most firms don't want to get their clients involved. That they want to keep it in-house, which makes a lot of sense. But that what that leads to is you really have to have strong documentation. And I'm sure, as Tim will tell you, that goes for all companies, but especially where you don't want to have your clients testifying about, an issue with a particular employee, it makes it even more important to make sure that you're documenting these types of issues, that you're able to provide backup documentation for the reasons for terminating or disciplining an employee.
How about you, Tim? Anything specific you're seeing just with regard to CPA firms in this area?
Oh, yeah, absolutely. I think part of the issues that, small to mid-sized firms wind up dealing with when they have these types of problems is something that Laura mentioned, which is documentation. A lot of firms, they spend a lot of their time, helping their customers, helping their clients, addressing problems, but perhaps losing sight of the back of the office type of HR component. So if they have a problem, it's typically lack of experience on how to address it and how to deal with it. So maybe, if an employee comes to you and they have an issue, you feel like you're addressing it by just talking to them, that's great and that's all well and good. But where's the documentation? The reason why that's key is because in certain instances, if you have adequate documentation, and you unfortunately wind up in litigation, there's a chance that you can potentially get the claim dismissed without getting to that jury, without having people making emotional decisions just based upon their own life experiences. So absolutely, documentation is key.
Okay, well, that's good to know that there are things that firms can do to prevent getting to a litigation resolution there. I'd imagine that these type of things are especially relevant for CPA firms that are growing quickly, both organically and through mergers or acquiring other firms. Some examples like that I see in my work with CPA.com is, firms adding a new practice, right? Adding a client accounting services or CAS practice, or adding a SOC audit or cybersecurity audit practice. where they're basically bringing in many new staff, oftentimes, non-traditional hires, people that, hiring technologists into a firm to do cybersecurity to do cybersecurity audits or, SOC audits and whatnot. So I guess like firms that are growing really fast, Laura, this would be even more applicable to them, correct?
Yes. And I think, when you're adding different types of practices and bringing in, let's say, more employees who are experts in cyber or other, non-accounting type employees, you're dealing with different cultural backgrounds, different issues, different expectations of where they've worked in the past. And I think, that all makes it more difficult for a smaller firm, because what used to be done casually, when you're a small firm, your culture, it's relatively casual. Things have to become more formalized as you grow, especially as you start bringing in different types of employees, like, those who aren't accountants.
Anything to add there, Tim?
Well, yeah, I mean, certainly when you are doing non-traditional hires and you're getting different types of people, it's like any type of business, right? The more personalities in a room, the more likely there's a chance that there's going to be a problem down the road, which is why, legal compliance, adequate training, the HR type of component in a company should always be addressed whenever a company grows.
Staffing up HR is typically not something that's at the top of the list for any organization that is looking to grow. So the burden on the HR staff is, continues to increase, especially if you're doing a lot of hiring, and now you have a lot of these types of like I said, potential things that the firm isn't used to, that the HR department isn't used to. Personal story. My wife has worked. My wife's a social worker, and she has worked with persons with developmental disabilities for much of her career. And kind of part of that is like getting them placed in the workplace and ensuring that they're kind of set up to succeed in the workplace. And, for a lot of smaller companies and smaller law firms and accounting firms and other small businesses, it may be the first time they've had someone with a disability, or, is just basically different than what they're used to there. So I know, Laura, you have access to liability claim data, both anonymized and actual. So like what can you tell us from the data? What is that telling us about EPL risk for CPA firms?
So looking just at the past 3 years, and this would be all different sizes of firms, but what we're seeing is that most of the claims involve terminations. So it's the claim is filed when someone is fired. Obviously, they're upset they've lost their job. So it's usually, I've been discriminated against when I was terminated, or that's when you'll get a sexual harassment claim, or you'll see allegations of disability discrimination. So for the most part, most of the cases that we have in the accountant's book do involve terminations, which just underlies the importance of making sure your documentation is accurate and that there is documentation to support your decisions, particularly when you're terminating someone. The types of claims that we're seeing are typical. Sexual harassment is one of the top ones. But interestingly, we also see disability discrimination or failure to accommodate a disability as one of the top allegations. And I think while everyone has spent a lot of time and effort trying to prevent harassment in the workplace, which is very important, I think some firms may have forgotten that there's other issues that have to be dealt with too, like disability discrimination, like accommodating someone with a disability. And I think, this just illustrates that while sexual harassment is very important to focus on, that there's other areas in employment law that also firms need to pay attention to. And the third one that we see a lot, like we mentioned before, is retaliation. So I think that's pretty consistent, Tim, with what you see overall with respect to employers.
Absolutely. And I couldn't agree with you more when you talk about, how sometimes employers forget that there are other types of claims that are out there, right? I mean, certain jurisdictions have pushed over the past year and a half or so as a result of the Me Too movement to have mandatory sexual harassment training. And a lot of employers, even if they don't necessarily have a designated HR function within their business, will at least know enough to say, all right, we need to do this type of training. And they'll do the training and they check the box, and hopefully somebody gets something out of it as a result. But what we like to always tell our clients is sexual harassment is absolutely important, but that type of training, use that as an opportunity. Train your staff on other issues. Talk to them about issues like disability discrimination, reasonable accommodations, the interactive process, that type of stuff. And at that point, it also sends a message to the staff that, look, we treat all these issues the same. We treat them all seriously enough.
No, that's a really good point. Does this what you guys are just talking about, does that also apply to the interview process? Because I'm sort of thinking about, with the increase in remote workers, for example, and again, growing firms doing a lot of interviewing now, perhaps doing a lot of interviewing and a lot of interaction electronically, or remote with remote workers and whatnot. Does this also apply to the interview process? And is there a remote element?
Well, generally speaking, the EEO laws, the anti-harassment, anti-discrimination, those types of laws, those apply in every single aspect of the employment relationship, whether it be interviewing, onboarding, certainly during the course of your employment, and God forbid you get there, termination. The law applies at every single aspect.
Okay. Are you seeing any claims in that area, Laura? Are we seeing that, are claims being made? Are there potential claims regarding the interview process?
I mean, we have seen that here and there, not so much on this book, but in general. Again, as things change, looking forward, I'm sure we can anticipate seeing a little bit more of that as well. Okay.
And how about, what do you see as things changing with more and more remote workers? Anything specific to that you can think of, Laura?
Well, I think just in general, it's more difficult for employers, especially if they haven't had a lot of teleworkers. It's more difficult just for managers to be running a team, to keep people engaged, to be able to review their work, and to document deficiencies. I think that's just more of a challenge, at least initially. So I think, there's going to be a little bit of a time for people to, kind of ramp things up, and there's going to be a learning curve. But that's one of the areas where managers need some training, I think. I think as we move to more teleworking, managers need to be trained in different ways to interact with their staff. And also, I think we have to be very cognizant of the fact that, there could still be harassment in other types of employment issues. And those employees who are teleworking need to be trained, with respect to anti-harassment, anti-discrimination laws, and make sure they also understand how to file complaints should they need to. It's one thing when everyone's in the office, it's a little bit easier. So you have to make sure if they're teleworking that they understand how to do all that.
Yeah, and with telework, that can be can lead to a whole host of claims, right? You could have potential wage and hour violations. You could have claims of sexual harassment, or even just telework in general, because apparently that's now the new norm. There are going to be issues when it comes to disability discrimination. Even if and when the sudden influx of teleworkers eventually will be able to go back to their brick and mortar buildings, you'll have instances of employees coming forward saying, hey, I need an accommodation, I for disability issues or otherwise. I'd like the opportunity to work from home occasionally. And employers are going to have to be prepared to address those issues.
No, and that makes sense. I'm thinking myself, for me to be able to work from home, I had to have certain software installed. I had to sort of set up a different kind of workstation. All of that was provided for me at my office, but having to work remotely, there were things that I needed in order to be successful at my job. So I can see that multiplied, especially for people with disabilities. So that makes sense. So Laura, the numbers, are you seeing, are there any numbers sort of stand out, that you can talk about, as far as claim, like how big do claims get? What anything in the numbers that sort of jumps out that you think would be of interest to the listeners?
I mean, I think the important thing to remember with claims when you're talking about damages or settlements is that it really isn't reflective of the size of the firm or company. A lot of these claims have an emotional distress component. So a lot of smaller employers feel that, they're a small company, they couldn't get hit with a large verdict or have to have a large settlement. But that's not necessarily the case, particularly when you're looking at sexual harassment and other types of claims like that. So I think that's really an important piece of all of this.
And I, in a recent interview I did with Rebecca Toffolon, one of the things we talked about was this concept of a pain period, which is kind of from the time a claim is made until it's ultimately resolved. The firm has to deal with it. Basically, the firm has to apply resources to it in a number of different ways. And I could see, especially if it were a claim around sexual harassment or whatnot, that would really be magnified with an emotional element as well. So it's really not just about the damages, is it?
No, not at all. And keep in mind, too, when you're talking about harassment, one of the things that an employer has to do when they become aware of allegations of harassment is to conduct a prompt and thorough investigation. And you really need to have someone trained in that area. So you're either going to have someone in-house who's highly trained, or you're going to have to go out and retain an attorney or someone else who is trained in investigations. And unfortunately, a lot of firms, especially on the smaller side, may not understand that, may not even be aware of that. And they may try to either brush it off or, hope it goes away, or tell people they got to figure out a way to work with each other. And that can be one of the most dangerous things to do. And I'm sure, Tim, you see this all the time.
Oh, absolutely. I mean, look, when an internal complaint comes in, and I don't care what size employer you are, when an internal complaint comes in, that should be the thing that comes to the top of your pile. Because if you address it adequately at the onset, you can nip it in the bud and prevent the potential claim from growing. Maybe we can avoid going to litigation. Maybe we can avoid having that employee go out of house, file an administrative complaint, seek a plaintiff's attorney. Maybe we can avoid all of that. Because look, if you don't, and if sometimes litigation can be unavoidable, but if you get there, the cost of a litigation is not just the dollars and cents that you're going to wind up paying to your defense counsel. There's an emotional component on an employer. There's morale problems. There's a sweat equity problem. Because it's not as if your lawyer will just handle everything by him or herself. You will have to be involved as well. You'll have to assign resources to address the problem on a going forward basis.
Yeah, no, that makes sense. And I like the term you pointed out, a potential claim. Ideally, you address something before it becomes a claim, and definitely before it becomes a lawsuit. Anything that is a potential claim needs to be treated. It needs to be, like you said, go to the top of the pile, because you can basically, like you said, nip it in the bud. So I think that's really good advice, is to treat potential claims as extremely urgent and important, because you can prevent a lot of ramifications later on. So when things do progress, though, and they do become they do end up in litigation, are we talking like relatively big damage awards? So Tim, what have you seen out there? What sort of, for firms that haven't had any real exposure to this, and we're kind of telling them they need to protect themselves, but how bad can it get? What do claims, what do payouts look like?
Look, they certainly can get very, very bad. When we talk about payouts, that could be anything from a jury verdict to a private settlement. And, for a lot of these types of claims, it's almost essentially a mathematical computation, right? Under statute, you look at what the plaintiff could be entitled to, and there's an economic damages component, things like lost wages. So if we look at a standard termination claim and an allegation of, I got fired because of my fill in the blank, whatever the protected category is. I've been out of work for a year and a half. Okay, well, what was the person's salary? And times that by 1.5. But the biggest problem there is the emotional damages component. Because emotional damages awards can be done on a sliding scale. There's anything from what people in the business call garden variety emotional damages. Those are the things like the stereotypical, I couldn't sleep, I couldn't eat, I was so upset. The thing that any one of us would deal with if we wind up losing our jobs. And garden variety emotional distress damages can be high. I mean, I'm a practitioner here in New York. And there's a couple of cases out there that indicate that a 6-figure garden variety emotional distress damages award is feasible. But that number gets increased even higher if that plaintiff seeks help. They treat with a physician or they treat with a mental health professional. Suddenly that number increases overall. And the other piece of the overall component that you look at when you look at these claims is attorney's fees. And now I'm not just talking about the fees that an employer would spend to defend. A lot of these laws and statutes that are in place regarding employment discrimination and harassment, they're fee shifting, meaning that either in a settlement or in a verdict, the employer would also be paying the plaintiff's attorney's fees. And I'm sure you can imagine how a plaintiff's attorney will say that they've worked many, many hours on a case, no matter what level you're at.
So I think you're talking about if it does end up going to a trial and whatnot, like you said, 6-figure, and then if you kind of add in attorney's fees and emotional damage where they've consulted with physicians and whatnot, even into 7 figures. So that's some that's some big numbers that you definitely you don't want to ever play in that space if there's a way to get ahead of it.
Absolutely, and then in certain cases, even punitive damages can be provided, which punitive damages are punishment damages. And I would imagine Laura would be able to comment on that from an insurance component, but those are the types of damages and those are the types of numbers that keep me up at night.
I think you're right, Tim. I had a little bit of a hard time hearing you there, so I'll just kind of recap. You're talking about, and there's also punitive or punishment damages, which can really take the number up. That's where the court is attempting to set an example, I guess, to basically say, look, we don't want to see this kind of behavior again from your company, and there's one way to really get someone's attention, get a company's attention is to punish them over and above just what just the kind of the garden variety that you were talking about. Would you say you group things into there are potential claims that you as the insurance firm, there's kind of potential claims, there's claims, and then there's when it goes to litigation. Are those kind of the 3 categories that you work with?
Well, it's really different. You really have to look at the definitions that are in the particular policy. So there is a definition for potential claims. What I deal with primarily, though, are helping our policyholders even before that, trying to give them the resources so that they understand, what the issues are, so that they understand why documentation is important, so that they understand how to handle all these things when they come up. That's really where my focus is primarily.
This whole idea of prevention and the fact that there are resources available, I think, is good news for the listeners of growing organizations, growing firms. That makes me think about how kind of easy and natural it is for a successful small to medium sized company, to maintain their great culture and have effective internal communication, but then how those 2 things can really become a challenge when there's rapid growth at the firm. Things that were once kind of easy and taken for granted now need to be part of the plan to maintain kind of their culture and the way things work, and to ensure healthy, sustainable growth going forward.
Absolutely. And that's where training really comes in. And Tim mentioned it before, there are some state laws now that require anti-harassment training, but that's just the beginning. And I think, unfortunately, a lot of companies, including, CPA firms, look at it as this is what I have to do and that's it. It's really just the beginning. And training on all types of discrimination prevention, all types of harassment prevention. Remember, we talk about sexual harassment a lot. That's what's been in the news with the Me Too movement. But there's racial harassment. There's harassment on, other types of protected bases. So it's really important that employees and managers are all trained in the prevention of all these types of discrimination and harassment. And then you really have to also provide training to your managers so they know how to handle issues as they arise. So all of this is really very important.
So kind of knowing the potential risks with EPL liability for growing firms, what would you suggest firm leaders do to decrease the risk and keep their growth and success on track? You mentioned a few things, but anything else, like in general, advice you would give to the leaders of these firms?
Well, one of the things to consider is the purchase of employment practices liability insurance. And in addition to the coverage that you get through an EPL policy, many carriers, particularly CNA, provide resources that can help you manage the risk. So if a firm purchases EPL from CNA, we offer complimentary access to our online web platform, Beyond HR. We provide online anti-harassment and anti-discrimination training free of charge, but there's also a lot of articles, podcast information there. Employment law is changing so rapidly, and it's very difficult for someone who's not, in human resources to really, understand all of the different ramifications of the changes in the laws. By having this online platform, it helps for our policyholders to stay abreast of all the different changes. We also provide a hotline for our policyholders where they can speak directly with an employment practices liability attorney to get advice on certain issues. We provide a phone consultation of up to 30 minutes per month or 6 hours per year. So, in addition to the purchase of the policy itself, there are a lot of risk management type of resources that are provided that are available.
That's good news for companies that for firms that are just sort of hitting that threshold to where maybe it's time they consider their first EPL policy for the firm, or perhaps they have something and they need to enhance it. That it really it can come with a variety of resources that they really should have anyway at the firm in order to do these kind of trainings and whatnot. Anything you can add, Tim, about kind of the way a firm can maybe set the tone at the top to prevent litigation down the road?
Sure. I mean, in my experience, the most successful firms, the ones that really are able to avoid claims, they're the ones that take these issues seriously. It starts at the top. If you as a principal in an organization take these issues seriously and do what you're supposed to do your due diligence, do your training, properly relay messages to your managers, make sure that they're taking it seriously. There's a trickle down effect, and on top of just the overall adequate training that you're going to need, when issues arise in the workplace, and they will, because we're social creatures by nature, and sometimes things go awry. If any organization, if they address it appropriately, they do their proper investigation, they address any and all issues, they follow up with their employees to make sure that everything is fine. That's a perfect situation, because at that point, the principal of the company is not just pitching to that one employee who's having the issue, because employees talk. They're pitching to everybody. So if you handle a problem adequately from the onset, it's a message to the rest of your staff. Hey, look, this place takes these issues seriously. This is the type of place that I want to work. This is the type of place that's going to be successful. That pays off in dividends.
Kind of setting that tone at the top regarding maintenance of a non-discriminatory and safe workplace. I can see how staff and even the partners, that they'll absorb that and they'll emulate what they see and hear from their boss, from the managing partner or the partner heading a particular practice. So I think that is really important. And one element we didn't really talk about too much, we didn't really talk about directly here is kind of reputation risk. The fact that if there are issues and if things are not handled in a professional way, that's going to get out one way or another. That's going to get out to industry. It's going to get out to clients, potential clients. And for companies that are growing, that's going to get out to potential employees. When you're trying to hire, to establish or to basically execute on your growth plan. If there are issues like this that we've talked about here that were not prevented, that were not addressed when they did happen, that's really going to hurt your reputation, and it's going to make the execution of that growth plan even harder. So while we wrap up here, any particular resources you would recommend for firms? I'll start with you, Laura.
It's important to have a connection, with an employment law firm. I think, like Tim's firm, there are a lot of resources online that can be really helpful. In addition, if you do purchase EPL, to take advantage of the resources that are provided. The EEOC on their website, eeoc.gov, has some information for small businesses that small firms can take advantage of that can be helpful as well.
And Tim, any resources that you would recommend for firms?
Whichever counsel you wind up working with, they're going to be able to provide you information, keep you up on current trends. I mean, just by way of example, I can tell you that on our website, jacksonlewis.com, we have entire sections of articles and blog posts that get pushed out immediately once there's a change in the law or there's a new case or new guidance from one of these agencies like the EEOC or the DOL. Staying abreast of these topics and getting out ahead of them is the most important thing that you can do.
Great advice, everyone. And the numbers we sort of talked about, I think, back up the importance of what we talked about. I'll also add that, like we said, setting the tone at the top in this important area will likely bolster the efforts to maintain a great firm culture as a firm grows. So I'd like to thank our guests for joining us today and for helping firms as they innovate and transform to better serve their clients. Thank you very, very much for joining us today, Laura and Tim.
Thank you.
That was a great segment with actionable insights on a topic impacting firms and really any growing organization. It was very interesting to learn that retaliation was and is such a prominent item. Next up, I'll turn it over to my friend and colleague, Matt Towers, as he and his expert panel get into a discussion which spans peer review and matters for consideration, and how to build a quality and risk wellness plan in our third and final segment today.
My name is Matt Towers, Product Lead for Assurance Services with CPA.com. CPA.com is the technology subsidiary of the AICPA and is tasked with helping bring the profession forward into the digital age through practice transformation services and technology solutions. Today, we'll be discussing the importance of building a firm quality wellness plan. In this discussion, we will not only hit on key reasons why this is critical for firm success, but also what a solid plan might include and what firms can do to begin creating and executing against a plan today. Joining me in the discussion are three special guests. First, we have Richard Hill, Managing Director at Mitchell, Emmert & Hill, a CPA firm located in Knoxville, Tennessee. Richard has participated as a peer reviewer for many years and brings insight into the challenges and approaches that small firms take in quality assurance around attest and assurance engagements. Glad to have you on the call today, Richard.
Thank you. It's a pleasure to be here.
We also have Kristy Illuzzi, Senior Technical Manager and Staff Liaison to the AICPA's Technical Issues Committee on the line. In her role, Kristy regularly interacts with small firms and understands the challenges they face and often brings their voice into AICPA discussions. Thanks for joining, Kristy.
Happy to be here.
All right. And lastly, we're joined by Mike Glynn, Senior Manager with the Audit and Attest Standards team at the AICPA. Mike works with the Auditing Standards Board and the Accounting and Review Services in developing and issuing standards for audits, attestation, review, compilation, and financial statement preparation engagements. Welcome, Mike.
Matt, thanks so much for having me. It's my pleasure.
Great. I'm looking forward to tackling this subject with all three of you. So first, I want to kick off asking a question. Why is it important to talk about having a wellness plan for firm quality around attest and assurance services? I know we've looked at data from peer reviews, and that kind of points to some trends. So I'm wondering, what exactly have we looked at, and what sort of things have we learned?
Well, Matt, I'll take that. This is Richard. I think I have a fairly comprehensive view of the challenges of smaller firms in complying with professional standards. As a firm of fewer than 10 professionals, I operate in that small firm environment. I've been very active in the peer review program of the American Institute of CPAs, performing my first peer review in 1992. And I perform about 25 reviews a year. 80% or so of those are for firms who do not perform audits. So they do preparation, compilation, review, some occasional attestation engagements. And a lot of these firms that I work with are smaller. They have anywhere from 1 to maybe 3 partners or 3 professionals in the firm. So they're fairly small. I'm a former member of the AICPA Peer Review Board. I'm a current member of its Oversight Task Force. And in that role, I visit with other administering entities in other states throughout the country to look at their processes and their reviews and how they handle the program. When I'm not doing that, I serve as the chair of the Tennessee Society of CPAs Peer Review Committee, and I sit on the committees within Tennessee that review and accept the report. So I get to see a lot in peer review, and that really helps provide me a pretty good perspective on the challenges those firms face. I don't have recent information, but as of a few years ago, there were about 25,000 firms enrolled in peer review, and a remarkable 85% of those have fewer than 10 professionals in them, and something like 70% have fewer than 5 professionals. So you can see the peer review program is largely made up of these smaller firms, 10 or fewer professionals, and admittedly, the larger 10 or 20 firms probably have as many hours of accounting and auditing work as the smaller firms do, but just from a number of firms' perspective, again, 85% of the firms have fewer than 10 professionals that are enrolled in peer review. 1 to 3 person shop just doesn't really have the resources that the larger firms have. They don't have a room of technical staff that research the standards and develop templates and tell them how to implement the standards. This is a job those professionals have to do. And unfortunately for many of them, they do that when they're not opening the mail, going to the bank, trying to fix a leaky roof, taking the trash out, and trying to replace, a receptionist that quits abruptly. So they constantly juggle priorities, as we all do, but I think there's just a different pressure in the small firm environment. Really, complying with the standards should be pretty easy. The standards are out there, they're available, and most of these firms have third-party practice aids. And those aids cut the crust off our sandwiches and cut them in half and make them easily digestible. There are example reports, example letters, there are checklists, all to help a firm comply with the standards. So why is it that these small firms are still struggling, and why are all firms struggling to a degree to comply with the standards on compilation, preparation, and review? I'm not trying to excuse small firms in any way or large firms. I'm not making excuses for anybody. If we accept an engagement as a professional, we've got a duty to do it right. It doesn't matter what the challenges is. If we accept an engagement, we have to follow the standards, but there's some element that's missing. Now, admittedly, peer review's gotten a lot tougher in the last few years as we try to meet the needs of the users and keep a self-review program intact. Much of this is focused on audits. You've heard of enhanced audit quality initiative and must-select engagements that involve the public interest and all that, but preparation, compilation, and review work is important too, and peer review, as a reminder, peer review doesn't go beyond the standards in any of these engagements. We're just trying to get firms to follow the standards. So I've observed a lot of firms struggling with 3 issues primarily. This is based on my experience. That's in reporting, in getting a proper engagement letter, and in documenting review procedures, the analytical procedures and the inquiries that are required on a review. And data gathered by the AICPA peer review program affirms this same information. Nearly half of all the matters that are developed in a peer review surround these 3 areas. And the thing that's surprising me, Matt, is that there have been no new standards issues. There haven't been new substantive changes in the statements on standards for accounting and review services. So it's not like there are new standards out there and firms are struggling to keep up with all these changes. The standards are largely unchanged for the last 3 or 4 years. And so the firms should be familiar with this, and yet they're not. I don't think any of this is a lack of interest on the firm's part. Never have I called a firm to review my comments on a peer review and gotten them to argue with me or to be anything other than upset that they didn't follow the standards. So there's something else out there. Maybe they just don't take these engagements as a primary service they're going to offer. Perhaps they are engaged to do a tax return for an organization, and then management says, well, while you're here, we need something to give to the bank, so will you also prepare a set of financial statements? So maybe that's part of it, too, is that the firms just aren't taking these engagements as seriously as they should have. One thing to know on preparation engagements, those aren't usually looked at in peer review, so peer review can do a lot to help a firm get better on these, but if we don't look at preparation engagements, those could still be being done incorrectly and that not surfacing. So I think the firms need some help. The last comment I would make would be that peer review is trying to respond to that a couple of different ways. One, years ago, if a firm missed something on an engagement, they would just simply tell us that they'll do better in the future. We would accept that. We'd move on. But now peer review wants to know how a firm will remediate that non-conforming engagement in accordance with the standards. And a lot of times, depending on the severity of the issues, they will ask that the firm allow somebody to look at a subsequent engagement just to make certain that they've corrected the issue. So while that's a little tough love philosophy, I think it's helpful because it's making sure the firms get it right. When those kind of corrective actions are put in, a firm actually gets better. So that's good. The other thing they're doing is this semi-annual newsletter that's just recently come out that peer reviewers will send out to their peer review clients. Those are highlighting issues that peer review is seeing, and I think that's things that peer review can do to help this need, but certainly the need's there. I've seen it firsthand in my practice as we make sure we try to follow all the standards. I've seen it as a peer reviewer. I've seen it as a committee member. And the data from the AICPA just reinforces this. These are real issues that these smaller firms, probably firms of all sizes, but primarily smaller firms, are struggling to comply with.
Richard, I'll add a couple thoughts because as you were talking about some of the reasons this might happen, something I've actually encountered in some of my research, and just to give a bit of background, with my role at CPA.com, I speak regularly with firms around challenges in this area to just better understand what are some of the problems that maybe haven't been solved through technology. And something that I've also heard is that it can be challenging to shift gears between service levels. And if somebody is doing auditing, for instance, to then transition that mindset down to a review level or compilation level or really take any levels of service, and it can be challenging. And I think there's also a certain element of how confidently does everybody understand where the lines are between each of these service levels, prep, comp, review, and so forth. So I think those things are probably contributing factors as well.
I agree 100%. I think auditing, since our days in college, auditing's always been presented to us as a higher risk engagement. You've really got to have skepticism and got to be ready to go when it's audit time. And I think you're right. A lot of firms probably lower their guard when it's only a compilation or only a preparation or only a review. And that's just the wrong mindset to take into these type engagements. I agree with you 100%.
And Matt and Richard, this is Mike. Just to add on there, Rich, you mentioned a bunch of different, practice aids and other things that are available for practitioners. The baseline for everything we do has to be the compliance with standards, and then everything, the guides and other things that we'll talk about later on in this podcast kind of build off those standards. Without a good knowledge of the standards, the foundation crumbles and the whole building comes down. So there's no substitute for that knowledge and having that, taking the time to go in and look at the standards and make sure you understand them. Both the ASB and the ARSC, of course, the ARSC being the group that issues the standards for reviews, compilations, and financial and preparation engagements, both went through a very painstaking process of clarifying the standards. That was meant to make them easier to read and to understand and implement, not for folks who write other articles and books, but for professionals who are out in the field doing these things, every day. So, and if you have that understanding in both like the audit standards, if you do audits, and the review, all these other things about fences and where one type of engagement stops and starts, that really becomes very, very clear when you understand like the level of assurance obtained in audit. And when you look at the review standards, you see that how much less that is. I mean, you really get a full feeling for what you are responsible to accomplish in the engagement. So a wellness plan, like anything else we do, you have to have that solid foundation of a good understanding of the actual standards before we build off on anything else.
Yeah, I think we're referring to the term firm quality wellness plan deliberately here, It's intended to be proactive. It's intended to be something that firms can do to prepare themselves to be successful, really even before the very first thing happens in an engagement. It's all about that preparedness. So I guess I'd like to see what else we might consider as part of a solid plan for firm quality.
I'll jump in here. This is Kristy. I work with the Technical Issues Committee, and for those that aren't familiar, the Technical Issues Committee is comprised of partners at PCPS, or Private Company Practice Section firms from all over the country. And they deal primarily with private company issues. They are smaller, firms. And so I get some good perspective on what they're struggling with. And I would say one of the major issues, I think, is just knowing the resources that are out there and how to access them, because I find from even at conferences that I speak at, sometimes things that I mention, firms are not even familiar that those tools are out there. And in a lot of cases, these tools are either free or low cost, options for smaller firms to take advantage of. And just to name a few, and I know that Richard and Mike probably have others that they're going to talk about as well. But, as Mike talked about the standards and the fact that they clarified those and tried to make them easier for practitioners to implement, those standards are available on the AICPA website for free. And the SARs include implementation guidance. Those are the A sections, towards the back of the standards, that really do walk through examples and illustrations and sort of how-to guidance. I know Mike's going to talk about the Comp and Review Guide, which is another great low-cost resource. Richard mentioned peer review. I think a lot of firms don't realize that they can leverage their peer reviewer. If you're having questions, if a firm is struggling with something, if you need a tool or how to handle a client, situation, whether it be firm quality management or adoption of the standards and how to apply them, I think utilizing your peer reviewer is also just a great, resource. I also worked years ago on the AICPA's technical hotline. A lot of practitioners don't realize that any AICPA member has access to that hotline. Those are live people that will answer the phone when you call, that are very technical, and you can ask any question in the A&A space. So if you have a question about a compilation, review engagement, an audit, a FASB, an accounting standards question, you can call the hotline and get a live person and a verbal response. The AICPA also, a few years ago, in response to helping smaller firms that don't have national offices, they launched the Center for Plain English Accounting. That's another great resource. They put out trainings and reports and illustrations of the standards. They also answer technical questions in writing, which I know a lot of our members were sort of asking for years, and we're now able to do that. It's a great smaller firm resource, again, that a lot of people just don't know about. PCPS itself, the Private Company Practice Section, is available at a very low cost for firms to join who deal mainly in the private company space, and they also have a lot of toolkits and resources available on their website for the smaller firms. So I do think in some cases it's just the firms knowing what tools are out there, knowing what's going to work for them, and perhaps even having a point person at the firm that is their expert, is their quality, management person that's maybe gathering these resources and disseminating information. I think sometimes too, it can be a bit daunting for a small firm. I look at a standard like RevRec under 606, and you're talking about hundreds of pages of a standard. And I think for smaller firms, some of this can be really overwhelming. So being able to digest, say, 10-page snippets or reports of some of the key issues, the peer review, findings, I think for the smaller firms is really beneficial.
Kristy, this is Mike. We really are doing ourselves a disservice if we don't take advantage of a lot of those resources, including, speaking to our peer reviewers, reaching out to other folks at other firms that are either within our network or whatever the case may be, availing ourselves of different alerts that are available and articles that are on, in the Journal of Accountancy or other publications, things that all great stuff, but that's all non-authoritative stuff that we go into to kind of, I still have this question when I look at the authoritative literature. Let me go out and pick someone else's brain and see, how to get there. And that includes all that stuff, those practices are developed by third parties out there. Those aren't authoritative either. So we still have our responsibility always to make sure that, job one and job two are both, make sure we understand the authoritative literature, the standards themselves, and the authoritative guide, and then everything else builds off of that.
No, that's great, Mike. I was thinking about resources in a way that kind of talks about, like, with respect to what you just mentioned and adherence to the standards. I think one of the challenges that we want to talk about or can get into as it relates to how to remedy or what resources can be helpful. One of the challenges is being able to kind of get some muscle memory, for lack of a better term, around how to approach this. And in my role, I am very strictly looking at the impact of technology on process. And this is an interesting area because one of the products that I oversee is called On-Point PCR, and the PCR part refers to prep, comp, and review. And in talking to dozens of firms over the last year plus about prep, comp, and review services, it's increasingly apparent to me how much firms rely on their technology in these areas. And unfortunately, what I've seen is a lot of firms apply what I would say is maybe outdated approaches to leveraging technology. They're kind of doing things that they're comfortable with and maybe not fully looking at the way technology can have an impact. So when I mention muscle memory, I think the main thing that is proactive about this is that when a firm's looking at technology, looking at what can they do on the front end to configure templates and standardization into the way they approach these different service lines. And that way, when the time comes, there is something already sort of built into their process. It doesn't replace the need for the firm to have the ultimate responsibility to make sure everything adheres to quality and the standards. But what it does do is it incorporates into the process the things that the firm needs to consider and should be doing as part of how they work. All of this research really applied towards the way On-Point PCR was built, for instance. So things like being able to say, we know, I think, Richard, you mentioned early in the conversation that one of the things that you've seen regularly, I think you mentioned top three most common things. You mentioned engagement letters, and you might have said rep letters too, but letters in general and language and so forth. And this is the kind of area where we saw that and we said, well, what can we do to help, and how can technology help? And the product essentially was built in a way that says, well, when somebody goes through their methodology, let's connect that methodology to the actual language that ends up flowing into the letters. And it helps automate some of the steps, even though the firm obviously has a responsibility to reviewing and making sure everything does adhere. Technology is one of these areas that firms can get lost in it. And if you take a process that just really isn't very efficient in the first place and try to apply technology towards it, it's really not going to fix the problem. It probably magnifies it. I think a lot of firms understand that to be true. So there's an approach towards technology that I think is really important that firms build into this plan.
Man, I'll jump in. I think something like that's important because peer review comes in after the fact. And so there's only so much we can do. It reminds me of the joke I heard years ago describing an audit, that an audit comes in after the war's over and stabs all the wounded people. And so to that end, peer review comes in after the engagement's already out the door. And so that's not really a tool that's going to help identify an issue before it happens. It comes in after the fact and points that out to the firm. Then they have to respond to an engagement that's already been issued. So I think something that gets out in front of that type issue that the firms are dealing with is more helpful, more a fix in real time than peer review is.
I couldn't agree more. I think the role of peer review is obviously important to kind of keep a consistency across the profession in terms of the approach. And the comments you made earlier, Richard, around the improvement in the audit quality and so forth. I think many firms don't realize, and this was mentioned a little bit, but standards haven't really changed significantly in quite a while. And it's simply the rigor in terms of how do we approach peer review and making sure that there's appropriate rigor and accountability in the process. That's really what's changed, and it's a very good thing for the profession. I think it was a Gallup poll from 2018 that I recall seeing talking about the most trusted professions, and the profession of accounting was, I believe, top 5 or 6 in terms of most trusted. And one of the reasons is this self-regulation that the accounting profession does, which is really unique to the profession. And so peer review in that regard is very helpful.
We are, to my knowledge, the only profession that invites this level of self-critique. And the other professions, I think, sometimes think we're crazy for it, but we want to make sure the work we're doing is at the highest level. And this helps that. When peer review first started, it was more of, it's always been educational and remedial, but it was more best practices and coach people and all that. And now it's taken on more of a stronger tone, I guess I'll say. But I think we had to do that in order to keep self-regulation on and to keep our position on that list. I've actually seen lists where accountants are second only to doctors in trustworthiness. And so we didn't get there easily, and so I think all this is important for us to keep our the confidence of the community in the work that we do.
So excellent. Well, let's try to wrap things up with kind of one final ask, which is, what if you had to just pick maybe one actionable step that a firm can take today that can help get them started in building out this proactive firm quality wellness plan? What would that be? Mike, I'm going to throw this one to you to get us started.
Okay, well, Matt, thank you very much. We do need to have, at our firms, have a process in place where the firm as a whole has, a way of understanding and of making sure that engagements are performed in accordance to the standards. If we're at a firm with multiple partners, that would be having, one partner be, maybe be in charge of quality control with respect to adherence to standards, and then set a methodology for the firm to follow. We're at a smaller firm that there's only maybe 1 or 2 of us performing these engagements. Well, then, our job might be a little bit more difficult, but we have to make sure we have, some way of ensuring that when we sign those reports that said we performed our engagement in accordance with the professional standards, that we know that we have in fact done that, not kind of relied on something else to ensure that for us.
Thanks, Mike. I'm going to chime in with mine very briefly, which I just touched upon a few minutes ago. I would say if you have not evaluated your technology stack around these services in some time, and I think even if you've done so as recently as a couple of years ago, everyone's probably aware of the fact that technology is moving very rapidly. So it's definitely worth looking at that, evaluating it, seeing are there places where your technology could be holding you back. So I just recommend everybody do that evaluation. Take a look and see where are your opportunities to potentially improve, in particular improving that ability to be proactively set up for success around the quality of your work.
Yeah, Matt, and I think another thing firms can do, and I think I mentioned this earlier, but assign someone from your firm to be that champion, and maybe that person who is going to determine, what your technology is, what tools you plan on utilizing to be able to carry forward the standards. As Mike mentioned, you got to make sure you're following the standards, and you have to read the standards, but then there are also some tools and resources to help you out, along the way. So I think, first and foremost, firms need to decide who is responsible, at the firm for doing that, for taking that stock and helping decide which technologies they're going to use and which tools they're going to, take advantage of at their firm.
Great. Thanks, Kristy. Richard, take us home. What do you got for us?
Well, I'm going to have 2, but I'm piggybacking off comments that have already been made. To Kristy's point, I would encourage firms to engage their peer reviewers. We're limited. We can't be part of your system of quality control, but it's not unusual for me to get a phone call. I actually solicit these from my peer review clients. They'll call up and say, hey, do I remember there was a change in this, or have you run into this situation? Where can I go? I don't necessarily answer their question as much as I point them in the right direction. And then my closing comment, I started in accounting in 1981 as a young auditor, and I remember having 13-column green bar paper and adding rows of numbers across and adding them down, and then being frustrated when there was a difference in there. I mean, logically there shouldn't be, but inevitably there was a math error somewhere in this massive 13-column document. And today we use Excel, and so anybody younger than about 50 probably would be shocked to see a spreadsheet with a bunch of numbers in it that are manual that you have to add on a calculator. But Excel has automated that process, and so that's using technology very smartly. Likewise, in this case, the application would be to use technology where you can. It's not a substitute, I think, as Mike had said, for reading the standards, understanding the standards, applying the standards, but it's a good, helpful tool, I'll say, to help make sure that you know what's in the standards. And to the degree you can use technology, I think that's great. We've been a paperless firm for maybe 15 years here. But I know a lot of firms I work with are not yet even paperless. They've still got paper files. So they've got a longer way to go. But to everyone out there, no matter how far you are down the road of using technology, push yourself to go just a little bit further, because it truly will then let you focus on what's really important, and that's thinking about the standards and the best way to apply that.
Thanks, Richard. I might even add that if there are firms that are still paper intensive, in some ways it might even be easier for them to leapfrog a bunch of the progressive steps and go right to cloud services and some of the things that are available today.
Yep.
Yeah.
I agree 100%.
Richard, Kristy, Mike, thank you all so much for joining in this discussion. I think this is very insightful and certainly should be applicable for many of the listening firms out here today.
Thank you, Matt. What an interesting discussion you had with Richard, Kristy, and Mike. Great information for firms, especially small firms, to use to create their own quality and risk wellness plan. That's a good place to stop for today. We've had 3 great segments with experts in areas where we can always use some thoughtful, actionable thoughts and ideas. There's plenty more to explore about these topics, so check out our show notes, and they will have links to all of the resources we've mentioned. To view them, just click on the episode's info icon in the podcast app on your smartphone or tablet, or open the episode in your computer's web browser. You'll find everything right there. I want to now mention that Modernizing Your Practice is also an ongoing program and content series with a goal to curate clarity around complex legal and risk management topics for firms of all sizes year-round. Found at cpa.com/MYP, you can access or share these 3 interviews and other pieces in the ongoing content series, which features a bevy of industry experts on key legal and professional liability risk topics in a variety of bite-sized and short to medium form content, all with an eye toward the transformation of today's audit and assurance practices. There are 2 other websites we'd recommend for listeners interested in taking this further. AICPA.store.com/go beyond disruption and cgmastore.com/go beyond disruption. Go there for courses, webinars, and other professional development resources that will help keep you ahead of the curve. Thanks again to our guests today. Of course, thank you for listening as well. If you've enjoyed the episode, go tell someone about it. You can even email us using the feedback link in our show notes. We'd love to know what you think and what you'd like to hear more of. From CPA.com in California, I'd like to personally thank Kyle Hannon and the Go Beyond Disruption team in London. We'll be back soon with more conversations that help you and your profession to go beyond disruption. Till next time, goodbye.
Thanks for listening to this episode of Beyond Disruption, brought to you by the Association of International Certified Professional Accountants. Learn more about today's topic at AICPA-CIMA.com/disruption. This podcast is designed to provide illustrative information with respect to the subject matter covered and does not represent an official opinion or position of the Association of International Certified Professional Accountants or any of its subsidiaries or affiliates. It is provided with the understanding that the association, its affiliates, and subsidiaries are not engaged in rendering legal, accounting, or other professional services. If such advice or expert assistance is required, the services of a competent professional person should be sought. The association, its subsidiaries, and affiliates make no representations, warranties, or guarantees as to and assume no responsibility for the content or application of the material contained herein and expressly disclaim all liability for such damages arising out of the use of, reference to, or reliance on such material.